Voluntary departure as a strategic tool.
Hello, greetings. I'm lawyer Edwin Fogam. I am an immigration attorney. I've been practicing immigration and other areas of the law for the last 28 years. I would like to discuss today a strategic use of voluntary departure. I had touched on this before, but because things are really taking a different turn as far as immigration is concerned, this is something I would like foreign nationals to think about and to consider if and when they are in immigration proceedings. That is the strategic use of voluntary departure. What is voluntary departure? Voluntary departure, whether post-proceedings or pre-proceedings, is a relief that can be granted to you instead of deportation or removal. In other words, instead of being removed from the United States, you are given the opportunity to leave the United States voluntarily. Why is this important? This is important because of the legal consequences of removal as opposed to voluntary departure. If you are removed from the United States or deported, you are barred to come back for 10 years. You cannot return to the United States for 10 years. However, if you secure voluntary departure, you can come back the next day if you have a valid way of coming back. For example, if you obtain a visa, you can come back in 1 week or 2 weeks. Now, voluntary departure can become very important if you have a relative or someone who can petition for you in the United States, either a family-based or employment-based visa. You can leave voluntarily, and after that petition is filed and approved, you can come back without any bar to admission, and you can re-enter the United States. That is how you can look at it strategically. Now, how do you qualify for voluntary departure? Of course, you must meet certain requirements. First, you must not be a criminal, or you must be a person of good moral character. Secondly, you must be able and willing to leave on your own. That is, have valid transportation, valid travel documents, and willing to leave the United States. You must not have been granted voluntary departure before, so you are not violating the court order again. And once you do this and you can leave, you can benefit from it. So even when you are in proceedings and you have other reliefs, you can think about this or discuss this with your attorney. I remember a unique case where an employment-based visa person here was removed, and he could be coming back and forth for his job on non-immigrant visa, business visa, and waited for his visa to become current. But because he had left the United States voluntarily, there was no bar. And when his visa became current, he was able to re-enter. He was able to be admitted as a permanent resident. So I hope this was helpful to you. If you have any questions, please don't hesitate to call us. Our number is 301-608-1555. You can also send us an email to info@fogamlaw.com. And as always, don't fear the system. Understand it, work with it, and you may benefit from it. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.